Let's go. The bar is open. What's popping, everybody? It's your favorite doc tender. Oh, wait, hold on. It's still early in the morning, guys. Ooh, baby. Get in here, get in here, get in here right now. Because at the end of the day, the bar is open, and you know what that means. That means that there is something going down with the Diddy trial. Y'all are not going to believe. First of all, I would like to say once again to myself. Yes, let me share this out to the spaces and places that it needs to be shared out to, because baby, let me tell you, the henny is hot. Thank you, goddess. The henny is hot. It's hot. It's scorching. It's burning. It's burning. We ain't even had a chance to really like open our eyes good before there has been Diddy trial drama. You guys, it's going down. It's going down. Your girl will be there today. I haven't had coffee. I would be lying if I said I did. I haven't had not one cup of coffee yet. I got to wash my face, brush my teeth, and boom, I had to jump up on here, throw me on some clothes real quick, and jump on here. I don't even have my earrings on. Matter of fact, I think I'm going to do this today. First of all, I need the hater blockers on, because I would like to personally thank everybody who has subscribed to the channel. I appreciate every last one of y'all. Make sure y'all are double tapping that screen. Let's go get them likes up. It's still early in the cast. Y'all aiding and abetting. Wait, let me baby walk y'all. Let me baby step y'all into this real quick. Kidnapping, gone. You heard me, gone. Arson, gone. But who said that those charges were kind of me? That's who. I said, when we went through the jury charges the other day, I said it, and I broke it down, and I explained why. Yes. I don't do that. And I'm going to start doing that, because your girl be on point. I be on point. Like, there's many insiders, but it's like I got the inside connect on what's going to happen. Okay? Baby. All right. And then aiding and abetting to SEX trafficking has been dropped as well. But I'm going to get all up in this. Let me send out. I'm misspelling my own damn name. I'm saying the Jenny is hot. We ain't got no Jenny over here. All right, you guys. So now I put this up. Mods, has it been shared out to everywhere? Hey, y'all. Top of the morning. I don't know who Jenny is. I don't know. I don't know. But whoever Jenny is, she popping. All right, let's see. Yes. All right, it has. Thank you, goddess. I appreciate you so much. So, top of the top, everybody. It's really top of the top right now. Boom. Let's get into this right here, because this is the government's documentation. I also have the defense. I am going to be doing a horizontal live later, breaking everything down with it clearly on the screen. But I had to jump up, pop up, and get this up here to y'all before, people started getting confused and all of that. So now let's talk about it. So in the first paragraph, which is this paragraph right here behind me, we have what the government is saying. All right. This is the government respectfully writes regarding its requested edits to the court proposed jury instructions. Okay. So now the government says They understand that the court's desire for streamlined instructions. With that in mind, the government has suggested ways to streamline those instructions. Specifically, the government has removed the instructions for the charges relating to attempted kidnapping under both California and New York law. Attempted kidnapping. Pay attention to the verbiage. Attempted kidnapping. Attempted. They have also dropped the charges for attempted arson. And they dropped the charges for aiding and abetting an SCX traffic. Now, I do not know if that means that they dropped the kidnapping and the arson altogether. To my understanding, that's what I'm being told, that's what that means. But I'm not sure if that means that the whole kidnapping and arson has been dropped as a whole, because they're saying attempted kidnapping, attempted arson. But I'm going to say that I believe that those charges are out. Either way, those are the weakest portions of this case to me. To me, I'm just saying, to me, as an outside who's inside of the courtroom listening and taking notes, baby, I've got 2 legal notepads and 4 notebooks, composition notebooks, filled to the brim, front and back, with notes from the case. I've been there. Plus, I also have transcripts, okay? Anyway, they also went on to give instructions for the SCX trafficking, which means they did not drop the trafficking as a whole. Oh, no. That's still there. They did not drop the forced labor. That is still there. And they gave instructions for that, very lengthy instructions on what it is that they are going to be giving the instructions to. They did not drop the conspiracy. They gave instructions for the conspiracy. They also have very, very lengthy breakdowns, okay? Henny Glasses in the chat if y'all want me to read it. Shout out to Italy. Hey, Cindy Ann P. I see you in the chat. Shout out to everybody. Respectfully, I think he's going to walk. We don't know. He might. Everything is up in the air. See, here's the thing. The defense never put on a defense, really. All they've done is attack the prosecution's case, which technically that's what they're supposed to do. But we didn't get the defense that we thought we were going to get, right? Where they were going to be calling in all of these witnesses and they were going to be counteracting, and people were looking for KK, and they were also looking for D-Rock. People were looking for others to show up in this case, and they're not. They're not. Now, y'all want me to read this? I see the Henny Glasses going up. I'm going to read this to you guys. And we're going to start with this page that is behind me. And how this is going to proceed is I am going to read and put the document behind me. But later this evening, I will go live and I will give you guys a full breakdown of everything that we know from today. Okay? Let me let the sun shine in. Woo! Or maybe I should put the sunshine down. I don't know. Either way, this is where we are right now. All right, so I have already read to you this first paragraph right here. Now let's get into the instructions for the sex trafficking and forced labor instructions, all right? And they said that while the government has taken seriously the court's desire for brevity, the government still strongly believes that certain limited additional instructions on the SCX trafficking and forced labor instructions, which are regularly given in SCX trafficking and forced labor trials in this circuit, are necessary for the jury to adequately understand the law on these charges. Each of these instructions, we are now here, each of these instructions, the government has serious concerns that the jury may misunderstand the applicable law for both charges, which are extremely complex legal concepts about which jurors may have preconceived, mistaken notions. So basically, I have lights. Kevin, you sound really crazy. I have lights. I was just in a room with a light on. but I wanted to come where the sunlight is. Please stay focused and stay on topic, baby. All right, so in their note down at the bottom, which is this part right here. Oh, y'all are so ignorant. Thank you. Thank you, goddess. What did you say? Trump gonna make the disappear because he's in a lot of the video. Trump's gonna make what disappear, babe? Oh, we're gonna talk about all of that Trump pardoning business because a lot of people don't realize certain things. I understand your stance, but anyway, before we continue on, let me explain something to y'all. Even if the government drops the kidnapping and arson altogether from the case, they charge them under California and New York law. California and New York law, there is no statute of limitation for kidnapping. That means that he's still not out of the water, out of the woods with that. Because at the end of the day, the state can still pick up those cases because they are federally charged state charges. Let me rephrase that. Rewind, come down, selector. So, California and New York have no statute of limitation for kidnapping. They can then pick up those charges and they can then charge him at a state level, especially being that the feds are going at the state level for these jurors to look at the law and decide whether or not they're going to charge him with the kidnapping. Michael, were you there? Were you there? The jurors were not smiling and laughing at Diddy, baby. I promise you they were not. They weren't. So he's still not out the woods. And if you want to say bribery is being charged and they're asking them to look at California law for that. Now, the tricky thing about the bribery charges, though, is that they have 3 years from the date it was discovered. And this alleged bribery happened, became knowledge to. I'm trying not to read y'all comments and go off on y'all. So I'm going to do this. How do I turn the comments off? Because I don't want to see none of y'all comments. I don't. Boom. No comments. Goddess, let them say whatever the hell they're going to say if they want to say whatever they want to say, because y'all cannot distract me anymore. That's what I was saying. Bribery, once it's discovered, you have 3 years from the date of discovery that the state can then pick it up and charge it, okay? So what y'all have to understand is Trump can give out pardons for federal charges, but he cannot give out pardons for state charges. Now, if he pardons Diddy, he pardons Diddy. If the state picks it up, the state picks it up. If they don't, they don't. Guess what? Here's what makes me different from a lot of y'all in the comments and a lot of these other content creators. I don't have a personal stake in this one way or the other. I'm reading to y'all the documents and I'm giving y'all my perspective as well as giving y'all the government breakdown. And thus far, your girl has been on point with everything that I have been saying, because yes, I was the one who was out here telling y'all why this was a one-man RICO before anybody else decided to go into why it was a one-man RICO. I was the one who was having people go into the predicate offenses of a RICO. I was the first one to say that stuff and have you guys actually go back and look at my Jane Doe video that I did a long time ago. Like, I think 2 months ago by now, I already broke down the 35 predicate offenses of a RICO before anybody ever knew what a predicate offense was. Before anybody else started breaking things down, I already did that. I was already on that. And then I was giving y'all commentary, showing y'all how they were lining up what they were lining up to build their case with those predicate offenses. I came and I gave y'all accurate testimony from the people. I didn't go from the defense and tell you the defense, and wasn't bigging up none of the lawyers. I have bigged up though. I'm lying, because I did big up Nicole Westmoreland. I did big up Brian Steele. I did big up where there needed be. I bigged up AUSA Comey and Johnson. I have bigged up some of the lawyers when they do good points. I have also come on here and said when it wasn't a good day. I've even said that I felt like Jane's case was shaky. So all of this, she's biased. She hates Diddy. I don't hate Diddy. I hate what's happening to Diddy. I hate that this situation is even there. And while everybody is out here trying to act like they don't see what we see, the fact of the matter is there's still things that happened that were done regardless. Oh, it's not a ring, that's domestic violence. And that's bad. That's bad. That's bad. No, he wasn't having sex with no prostitutes. They were escorts. They were being paid for sex. It's all through the testimony. Nobody ever said they came and put on a striptease or any of that. The truth is the truth, and you can't run from it. But you know what y'all not talking about? Y'all not talking about his addiction. And I keep saying this every video. You're not talking about nobody. Nobody is talking about how heavily addicted Diddy and Cassie were back then. And to the fact of the matter, hold on. Because Diddy never got clean. Thank you for the super chat, baby. I appreciate you so very much. Thank you so much. Diddy never got clean. They found him with illegal substances and freak off materials the night that they arrested him. So why is nobody talking about the fact that Diddy needs help? Why are we not talking about that? Okay. Anyway, back to what we were talking about. So yes, the kidnapping, even if it gets dropped as a whole, because I'm looking and I'm seeing that it's attempted kidnapping, and attempted kidnapping was a part of the jury instructions that they had. As a matter of fact, let me go back. I think I have it in this phone. Let me go back. And if I don't have it in this phone, I can get it for y'all because I have the documents. So let me look and see if I have it. I don't think I have it. No, it's not in this phone. It's in the phone that's in my hand. But I have the jury instructions that the government originally. Let me go there. Okay, with regards to the kidnapping, it says, if you found the defendant guilty of count 1, thank you for the Cashapp, babe. I appreciate you so much. If you found the defendant guilty of count 1, then please indicate whether the pattern of racketeering activity that the defendant agreed would be committed involved kidnapping, including attempted kidnapping, aiding and abetting kidnapping, or conspiracy to commit kidnapping in violation of New York law. If you found the defendant guilty in count 1, please indicate whether the pattern of racketeering activity that the defendant agreed would be committed involved kidnapping, including attempted kidnapping, aiding and abetting kidnapping, or conspiracy to commit kidnapping in California law. Now, that's why I said, wait a minute, skirt, just now when we were reading this, and I said, wait, they said they're dropping the attempted kidnapping. The attempted arson. But I feel personally like they need to just go ahead and just get rid of this kidnapping and get rid of this arson charge altogether if they haven't already. Get rid of the whole thing altogether, because those are the weakest points of this case, if you ask me. Why do I say that? Because we don't have any tangible evidence to back up anything. We don't have any tangible evidence to back up either kidnapping of Capricorn Clark in California or New York. We don't have any tangible proof of that. The LAPD officer testifying that he saw a bad boy vehicle outside of Kid Cudi's house twice, once going up the hill and another time coming down the hill. The night that the house was broken into and Capricorn Clark alleges that she was kidnapped. The officer said that he didn't see anyone in the passenger, like he couldn't see who the passengers were in the car because the car was heavily tinted. So he can corroborate that there was a bad boy vehicle outside of Kid Cudi's home, but he can't corroborate whether or not somebody was in that vehicle. And if so, who? Well, it's obvious somebody was in the vehicle, but he can't corroborate Capricorn Clark's story. He can't identify anybody as being passengers in that vehicle. So for me, those kidnapping, even though they may have happened or they may not have happened, those kidnapping charges are not strong. They are weak to me because I can't. And then with the arson, we've already gone over the arson. There was no witnesses, no nothing that implicated anybody from Bad Boy or whatever. For all we know, the dog walker might have done it because she was pissed off with him. He might have shortchanged her on some pay. We don't know. We don't know who did it, but he did. Kid Cudi did testify and say that once he left Cassie alone, that his home was never broken into again and nobody ever tried to Molotov cocktail his car. So we could assume that, yeah, Diddy did it, but we don't have any solid proof to that. So to me, that is those are weak right there. Now, the aiding and abetting in the X trafficking, that's the X trafficking, they've dropped that. But they still have X trafficking here, as you can see, because we were just reading this paragraph on the charges that they want. So this right here, they're still going after that. All right. So now, where were we? Let's continue. All right. And let me put the next slide up for y'all so y'all can see it. Honestly, you guys, I'll be going back to my horizontal live. So a lot of y'all will probably not see me in your timelines unless you follow me. So now we're on this page, which is page 2. And it says requested instruction 1, earlier consent, not determinative. All right. So they say, this the government now. We're talking about the government. And I'm going to read for y'all the defense as well, because we got something from the defense too. But let's get to this part because this is the part that everybody is buzzing about. All right. I'm not going to come and shortchange y'all. I'm going to come and give it to y'all raw. Anyway, due to the particular facts of the case, the government believes that it is imperative that the court inform the jury that prior consensual sex activity is not determinative as of whether a victim was sex trafficked. So basically what they're saying is, regardless to whether they were consenting before, that does not determine whether or not they were trafficked or not. Now, here's the thing. I could be your girlfriend and we could be having sex all the time. The one time I say no, if you decide that you want to take it anyway, that is illegal. You have now crossed the threshold of committing a criminal offense. All right. All right. So, as this court is well aware, the fact that this case involved instances of trafficking of Jane and Miss Ventura, wait, pause for a second. I want to ask a question to y'all, and I'm going to turn my chat on for this. Why do they keep referring to her as Miss Ventura when her name is Mrs. Fine? Mickey, you way off base. We never even talked about kids in this law in this case at all. Kids never came up. What are we talking about? Stay on topic, baby. I don't know why. Why don't they refer to her as Mrs. Fine? Is it because we the people know her as Miss Ventura? Is it because Diddy don't want to acknowledge her as hey, pretty ginger. Good morning. Good morning. Happy 13-month anniversary. I thought about that last week. You feel me, Olivia? Like her name, call her Cassie Ventura Fine. Her name is Cassie Ventura Fine or Cassie Fine. Happy 14-month anniversary, goddess with the edits. Have you heard some charges have been dropped? We discussing that now, Carla. The charges that have been dropped have been attempted kidnapping, attempted arson, and aiding and abetting sex trafficking. But the sex trafficking itself is still here. So that's why I'm saying I don't know if they dropped all of the kidnapping and aiding and arson or just a portion of it. All right. So now we are here. All right. Let me turn the comments back off. Hold on, you guys. There we go. All right. So we are here, and I stopped right here where it says Miss Ventura. Okay. So let me read that sentence over. It says, as this court is well aware, the facts of this case involve instances of trafficking of Jane and Miss Ventura that follow instances of consensual sexual activity, a topic that is likely to be discussed intensively by both parties during closing arguments. And it is Second Circuit law that earlier periods of consensual activity do not preclude a finding of trafficking as to later activity involving a victim. So again, they're saying that consensual has nothing to do with the fact that there was trafficking that was going on. All right. Again, this is the government's. We're going to read the defenses next, but we're reading the government's right now because that's what caused the uproar. All right. Now, they cited some case law, United States versus Vernier. All right. And it says in that case, recognizing that sex trafficking encompasses acts that compel a person to perform or to continue performing commercial sexual activity. All right. So they have said that there are instances where it was compelling them, according to the government, to continue with the commercialized sex. And remember, we talked about commercialized sex. That's when you give something of value in exchange for intimacy, physical intimacy. So that's considered commercial sex, okay? And what is that in this case? With Cassie, it was the roof over her head. It was her career. It was her livelihood, her money. She relied on Diddy for every single thing, okay? With Jane, they're saying that it was the rent, the roof over her head, and her monthly stipend. And I guess we can include her lawyer in this as well. I don't know. I'm going to talk about Jane in a minute when we get done with all of this. Somebody remind me to talk about Jane. Y'all make sure y'all get them likes up. All right. The same is true for forced labor. Now, in the forced labor case, they're going to tell you, all right, the government's forced labor theory focuses on 4 victims, Cassie and Jane, with regards to their participation in freak-offs or hotel nights, and Mia and Capricorn Clark. This is where the forced labor is coming into play at, all right? And where are we? We're down here in this paragraph right here. So if you think I'm not showing you the document, I am. All right, so it says, similarly to sex trafficking, Cassie and Jane's prior consensual activities do not preclude a finding that later non-consensual sexual acts are forced labor. And they cite United States versus Hung. And it says in that case, a victim's initial willingness to perform certain labor does not preclude the possibility that the victim's continued labor may become forced. All right. Nor an instruction in which the court indicated that the jury need not attach any real significance to witnesses' inability to identify the defendant in court. Okay. In addition, the government strongly objects to the defense's apparent claim that this court should not instruct the jury on well-established legal principles as to thorny questions of law because they are unbalanced and may help the jury reach a conviction. The government, just as the defendant, is entitled to legally accurate instructions about what its burden is and is not. So basically what they're saying is all of that the government is trying to put out there, they object to the fact that they're trying to say that they consented to it and, then later on was not consenting to it, how they've expressed that they didn't want to do this anymore, but kept doing it because they felt compelled. Again, this is the government side. We're going to read the government side, okay? I mean, the defense's side. So they're objecting to that, and they want the instructions to be very clear when it comes down to sex trafficking and forced labor. All right. So now we're down here. Oops, we're right there. All right. And there is no real dispute over the fact that these proposed additional instructions are routinely given in this district. are legally accurate and would help inform the jury as to the law on key issues in the case. So what they're saying is, look, we routinely give these out. When we have these cases, we give these instructions out to them. And so to not do it would not be what we do on a normal basis, and that it is the law for us to be able to do this, and that we must point out key issues in the case. That's what they're fighting for. And while the defense may want the jury to be confused on certain of these issues in the case, issues with the hope that the confusion will result in mistaken assumptions in their favor, there is no authority for omitting jury instructions on that base. So what they're saying is, even though, the defense wants to mucky it up and they want to cause reasonable doubt, because that's basically what that sounded like to me. Like they want to cause reasonable doubt about these charges. There's nothing in the law that says that we cannot do the instructions the way that we want to do them for these charges right here. So they're fighting to keep their jury instructions in for these two charges right here. All right. Does the fact that Mia and Capricorn willingly took jobs with the defendant preclude a finding that both at some point were forced to work? To avoid any confusion on these points and to ensure that the jury applies the correct law to these facts of this case, the government respectfully requests that the court include such an instruction. So to avoid any confusion and to make it fair, because remember, they said just like the defendant, which is Diddy, the government has the right to be able to have a fair jury instruction. Okay. So they want their instructions kept in. All right. Request instruction number 2, payment not determinative. Okay. The government respectfully requests that the court instruct the jury that sex trafficking / labor and payments to the victim that are conduct are not mutually exclusive. All right. For the sex trafficking, this instruction is crucial because of the fact pattern underlining Jane's trafficking by the defendant. As Jane testified, around April of 2023, the defendant and Jane entered into a multi-year love contract under which the defendant agreed to pay Jane's rent in the amount of $10,000 per month. While that contract was in effect and in part as a result of terms of that contract, the government alleges that Jane was trafficked. Because jurors may be under the mistaken impression that someone cannot be coerced if they received compensation in return, the government requests that the jury be instructed as to the law that payment alone does not preclude a finding of guilt of sex trafficking. So they're saying, okay, because they keep talking about, oh, we're on the next page. Let me switch the pages for y'all so y'all hear. All right. We're in this paragraph right here. So now what they're saying is they don't want the jury to get confused into thinking that, oh, just because there was a payment there, that takes away the fact that there was some alleged trafficking that was going on. Okay. And they want the instructions about the law, what the law says, not what the government says, not what the defense says, not what you say, not what I say, not what they say, what the law itself says about the payment. And then they cited United States versus Rivera, and they said that in that case, affirming convictions despite victim statements that the defendant paid them and they earned more money with the defendants than they would at their next best employment option. So that's a case that they cited where they were saying that this is a similar case and this is what happened. All right. Because the forced labor victims also received money or gifts from the defendant, it is important to instruct the jury that payment does not preclude a finding of forced labor in order to prevent confusion. As noted above, the defendant paid Jane $10,000 per month rent and similarly paid for Cassie's rent and other expenses. In addition, as employees, Mia and Capricorn were paid salaries by the defendant's company. The jury may not intuitively understand that this payment does not preclude a guilty finding on forced labor. So again, they're just harping on the fact that because everybody was compensated monetarily or received any kinds of gifts, that doesn't take away from the law that says that this is still forced labor. Don't shoot me. I'm just the messenger reading the document, okay? Because y'all love to come for me, boy. Y'all love to come for me. I'm quite sure if I turn these doggone comments on, y'all in here throwing fists, hands, and knee bows in the comments at me. Let me tap in with y'all. Okay, wait a minute. That's fine. You can say Jane Doe's a hoe. Okay, you guys, let's keep going. Listen, snipers, just delete comments because my numbers, let them do what they do. All right, now, cumulative conduct. The government's proposed additional charge language instructing the defendant that they may consider a defendant's cumulative conduct is particularly necessary in this case for the jury to understand what it can consider as assessing whether Ms. Ventura was coerced. Throughout trial, the government has introduced evidence not only of threats and harms directed at Ms. Ventura over a multi-year period by the defendant, but also the defendant's threats and abuse of others of which Ms. Ventura was aware. Then they say, under the law, the jury may consider all of this conduct as asserting whether a victim was coerced. So basically what they're saying is, look, Cassie, she was threatened, she was abused, people around her got abused, and she knows that people around her got abused. So this was coercive behavior that kept her in the situation to keep her safe and everybody else around her safe too. And they cited United States versus Purcell. Okay. And in that case, they said, viewing defendant's cumulative conduct and holding that government had met its burden of proving coercion. All right. Then they cited U.S. versus Wilkins. And in that case, it says, when evaluating if a defendant exerted coercive force over a complainant, juries are thus directed to evaluate the totality of a defendant's conduct towards a trafficking victim, including any threats or specific instances of past violence that may have created a culture of fear, such that the victim's conduct was rendered involuntarily. Now, pause, because I keep telling y'all that keep saying domestic violence, domestic violence. The defense is spinning this as domestic violence. It is domestic violence, but I kept telling y'all that they were looking at that as force and coercion. Didn't I tell y'all domestic violence is starting to be looked at as coercion? I told y'all this, but y'all want to come at me and you hate Diddy. You don't like it. You want to see him locked up. No, I want to see Diddy get help. And jail does not help anyone. It does not rehabilitate anyone and make them a better person. Anyway, back to what we were talking about. It says, however, without such an instruction, jurors may mistakenly believe that they are confined to considering a narrower category of evidence in deciding whether the elements of sex trafficking, okay, I'm good, sex trafficking are met. Okay, the cumulative conduct in forced labor the cumulative conduct in forced labor instruction is also important for Mia and Capricorn. Both worked for the defendant over long periods of time, and during their employment, the defendant was violent and threatened them. The cumulative effect of the violence and threats can be considered by the jury in asserting whether either was forced to engage in labor or services for the defendant. Without an instruction of this nature, jurors may feel that they are constrained to consider only whether a particular act of violence or threat resulted in forced labor. So now for everyone who was asking, why did they keep bringing all of these assistants? What was the purpose of bringing Capricorn Clark? What was the purpose of bringing Mia? What was the purpose of bringing all of these other assistants in to testify during the Cassie time period? Well, because this is what they were showing: pattern, cumulative behavior, which is pattern of behavior. So it's showing that there were instances of witnessing violence. And when people often witness violence, again, I'm just breaking down the government side of things. Stop coming for me. Okay. I don't see the comments, so they're not distracting me, you guys. That's why I said y'all could kind of fall back because I'm not watching the comments. It's not distracting me. But if they become disruptive, put them out. If they're disrespectful, put them out. Now, they're showing a pattern of behavior. And when people witness violence, it creates an environment of fear, which then makes people feel, hey, yeah, I don't want that to happen to me. So let me just fall in line. See what I'm saying? So that's been the government's case. And I pretty much have been breaking this thing down accurately to you guys. As you're seeing, as we're reading stuff, your girl has not missed. Not one time have I missed as of yet. I've been on point. All right. Physical restraint. Based on cross-examination of Jane and Mia, the government respectfully requests that the court briefly instruct the jury that physical restraint is not required to establish SEX trafficking and forced labor. Now, that's another thing, because a lot of people are like, oh, well, they didn't put a pow to their heads. They didn't tie them up. They didn't, lock them in a dungeon. So they were free to leave at any point in time. So they're trying to take that out of your mind and say to you, look, that doesn't have to be for this to happen, all right? As this court is aware, one of the key instances of trafficking of Jane that the government intends to discuss at length in its closing, oh Lord, at length, Jesus Christ, they're going to take all day for real. They're going to take all day for real, y'all. Ooh, they said at length in closing. Now, let me go ahead. Let me change are we still here? We right here, y'all. Oh, no, we're not right there. Hold on. Let me bring y'all up to date. Boom. Did I change it? No, it didn't change. Hold on. First of all. Okay, this is where we are. Physical restraint. All right. So I'm going to read that part again. As the court is aware, one of the key instances of trafficking of Jane that the government intends to discuss at length in its closing, and which the government anticipates that the defense will also address in closing, involves the defendant's assault of a subsequent freak off involving Jane in June of 2024. During cross-examination about the incident, defense counsel extensively questioned Jane about times that she could have escaped to this date, asking Jane, does the back gate have the capability for you to leave the house? Asking whether she has other family members in Los Angeles, which they did ask her. Moreover, during today's Rule 29, which was yesterday's Rule 29 motion, defense counsel again argued that Jane could not have been trafficked on this date because she could have left. Because of the defense's lengthy cross-examination on this point and expected arguments at closing, and to avoid confusion, the government requests that a very brief instruction be added on this point to make clear the legal import of this evidence. So they're talking about the freak off after Jane mushed Diddy's head into the marble countertop, threw candles at him where he had wax all over him, threw glass at him, and he in turn kicked in her doors and mollywopped and kicked her and drug her, and then forced, well, I don't want to say forced, but that's what they're saying. She's saying that she was then forced into a freak off because he said, you're not going to F up my night. She went and then covered her bruises with makeup, put on lingerie. She told him she didn't want to when they were in the bathroom. He didn't care. He gave her a pill, told her to take the pill. She took the pill, and they went and they had the freak off. That's the forced labor. Okay. Similarly, during the cross of Mia and in the Rule 29 argument yesterday, I'm going to say yesterday, even though this says today, I'm going to say yesterday. The defense repeatedly argued that Mia could have left her job at any time and is therefore not a forced labor victim. That is incorrect under law. Rivera 799F.3D at 184, affirming forced labor and sex trafficking convictions, even though victims once left the defendant but later returned. And the instruction is needed to correct any misimpression in the jurors' minds that Mia had an affirmative duty to leave. Okay, so basically they're saying that there's another case that backs up what they're saying. And if you don't know, once a judge rules on something in a court that's never been brought up before, the judges usually keep going with that. They don't go against that. So, and they're saying that just because Mia left and came back, or anyone left and came back, that's not reason enough to say that it wasn't forced labor. Which, while I'm reading this, it's making me go back to Dr. Dawn Hughes. Y'all get them likes up. Dr. Dawn Hughes and her testimony, and about the psychological aspect of things and how people how people respond to certain behaviors and things of that nature. It's taking me back to that. I'm curious as to whether or not they're going to use in their closing, if the government is going to use in their closing any of Dr. Dawn Hughes's testimony. I'm curious. Matter of fact, let me give y'all this. Get them likes up in the meantime. All right, here we go. If Sherman's in here, you're going to get a third option. I know you love those third options. All right. Tap the poll at the bottom of the screen. Will the government use any of Dr. Dawn Hughes's testimony in closing? Yes, no, maybe. Tap the screen at the bottom and let me know what y'all think. All right. So now we're going to move right along to this one right here. Okay. Requested instruction number 5. Defendant need not receive things of value. All right. The government respectfully requests that the court add a single sentence to its charge on sex trafficking to clarify that the defendant need not be the person who receives the thing of value from the SEX Act. Okay, this sounds like, for those who have been saying, what was his profit? What was his gain? The government believes that this short instruction is necessary here due to the particular relationship between the parties and potential the jurors will be influenced by preconceived misconceptions about trafficking that do not comport with the law, as it will be explained. And then they cited Noble versus Weinstein, or Weinstein. Is it Weinstein? Congress noted in that case that trafficking a person is not limited to the sex industry. A short instruction on this point is needed to clarify the proper scope of this statute. So they're like, we're not asking for a whole breakdown. We just want a little sentence to clarify. Now we're on this page and we are at requested instruction number 6. Commercial sex acts need not occur. The government respectfully requests that the court add a very short instruction reflecting the black letter law proposed that a completed commercial sex act is not required for a sex trafficking conviction. Without such a charge, a jury may incorrectly think that a commercial sex act may occur for a sex trafficking conviction. The phrase would be used to cause from the phrase would be used to cause. Those are quotes. That's why I did that. From the statute is not readily understandable by non-lawyers and may be misunderstood by the jurors as requiring that a commercial SEX act result. Second, this law is relevant to the fact that this case, for example, as your honor is aware, one of the specific instances of alleged SEX trafficking, which the government has focused on during its case, is the incident at the Intercontinental Hotel. The government has presented evidence that the defendant kicked and then dragged Miss Ventura in the direction of a hotel room where an escort was standing by and a freak-off had been in progress. A juror could reasonably find that even though a commercial SEX act did not occur immediately after the defendant attempted to drag Miss Ventura back to the room, the elements of this count were otherwise met at that time. So they're saying, look, the fact that he was trying to drag her back to that room, the fact that he used violence to try to get her back to that room, that's the important part. The fact that there was an escort in that room, that's the important part. And let's not forget that. That's basically what the government is saying in that part. That's what I took from it. Anyway, now we're at requested instruction number 7. Y'all get the likes up. The government respectfully requests a more detailed reckless disregard instruction. The government anticipates that one of the key disputes as to counts 2 and 4 will be whether the defendant had the requisite knowledge that Jane and Miss Ventura felt forced to engaging in these commercial SEX acts. While knowledge, a term people use in their everyday lives, is likely to be readily understandable to the jury, the government believes that additional explanation is needed to explain the term reckless disregard. Okay, to the jury, a concept in which non-lawyers are unlikely to have ever encountered. So they're saying that reckless disregard doesn't require knowledge, meaning that they don't have to be verbal and vocal and tell them that they're feeling forced into doing these things for it to be forced. That's what they're saying. Okay, for the conspiracy, which we're here, the conspiracy instruction. All right. The government's proposal also requests certain additional language outlining the law on conspiracy. The current definition is only a few sentences long, and the government is concerned that it may leave open too many unanswered questions for the jury, which will result in a number of jury notes seeking clarification. It is imperative that the jury understand that the law of conspiracy, a legal concept that is not intuitive, in order for them to correctly apply that law to the facts relevant to count 1, as well as the narcotics conspiracy predicate. The government has carefully gone through conspiracy instructions that are regularly given in this circuit and has only proposed adding that language that is directly relative to issue in this case. The government is available at the conference to answer any questions the court has about why such instructions are necessary for the jury to understand the case. So they want a definition given to the jury as to what conspiracy is. All right. Now they go into the effect on interstate commerce. Now I know a lot of y'all have been questioning, how does any of this affect interstate commerce, right? Right. So the government respectfully requests that the court add a short instruction in its discussion of the interstate commerce element of the racketeering conspiracy that narcotics actively had an effect on interstate commerce as matter of law. Indeed, the Second Circuit has found that narcotics activity satisfies the interstate commerce requirement for a racketeering enterprise. And they cite United States versus Miller, and they quoted, of special importance to the present case, we have held that because narcotics trafficking represents a type of activity that Congress responsibly found sustainably affected interstate commerce, the actual effect that each drug conspiracy has one interstate commerce is constitutionally irrelevant. It follows that whereas here, the RICO enterprises business of narcotic trafficking that enterprise must be viewed as substantially affecting interstate commerce. That's what they said in that case. And honestly, did I? Okay, this is where we are. And honestly, I feel like even with that, I see where they're trying to go with this drug trafficking thing, but I don't know if that's going to stick. I really don't, because he was traveling. Yes, he was traveling with substances state to state and out the country, according to testimony. However, I don't know if people are going to really look at it as that. Distribution, yes, he was purchasing it with the intent to give it to somebody. Like when he purchased the e-pills, he purchased it with the intent to use them at freak offs or whenever he was using them, because we don't know when Diddy was using them. So Cassie and Jane was using them during the freak offs. But I don't know if that's going to stick either, the distribution part. I don't know, but I don't even see distribution. I don't know, y'all. Anyway, they also went and they cited United States versus Feliciano. Okay. And in that case, they said, noting that VCAR case, that the racketeering activity that satisfied the jurisdictional element in this case, narcotics trafficking, is clearly economic in nature and has been found by Congress to have substantial effect on interstate commerce. I don't know. I don't know about this one, y'all. Further, in Taylor versus the United States, oh my goodness, y'all, they're citing this is all case. Okay, so just bear with me as I read it. All right. Taylor versus the United States, the Supreme Court found that the interstate commerce element of Hobbs Act robbery is satisfied if the government establishes that the defendant robbed or attempted to rob a drug dealer of drugs or drug proceeds, since as a matter of law, the market for illegal drugs is commerce over the United States has jurisdiction. Okay, y'all, are they reaching? Oh, I didn't mean to take that down. I didn't mean to take that down. Let's put that back up and let me see. Are they reaching with this one? Hey, smoked out, what's popping? During the defense's attempt for the acquittal, they mentioned an issue with the kidnapping and arson not being legal charges in California and New York. Did that prompt the dropping of those charges? I don't think so. They didn't say that those were not legal charges. They are legal charges. I don't know where you heard that from, babe, but that's not true. Kidnapping is a legal charge. It's an illegal charge. And in California and New York, there's no statute of limitation on kidnapping. No statute of limitation. To me, distribution is the sale of illegal substances. He didn't sell anything. Sean, I'm kind of with you with that. But at the same time, you don't have to. Like, there's been instances where parties have been raided and people had drugs everywhere. And because the person who did the party provided the substances, that's considered distribution because it was given to somebody else. So, but I'm kind of like, y'all have some things. Stick with the things that they have. Like, I don't know about this one, you guys. Cousin Pam said Diddy snitching. Somebody else said that to me earlier. And while the Second Circuit has not had the opportunity to apply Taylor to the RICO statute, it is held that Taylor applies to violent crimes in aid of racketeering, which is the VICAR charges. Okay. Right. I agree with you. These fine lines are what's making this case like, which contains an identical interstate commerce requirement. Okay. They go on citing Taylor and concluded that the requisite interstate commerce was here satisfied by evidence that the enterprise trafficked crack cocaine. We're not talking about crack cocaine. Now, when people were saying to me, that's not distribution, I explained to y'all where the government was coming from with that. But now that the case is done and that all they got to do is get these jury instructions down pat and do their closing arguments and it goes to the judge, now I can put my 1-2 in it because y'all ain't been really getting my 1-2 on it. This is a reach to me. And I'm going to tell you why. Because as they're citing these cases, oh, Anthony, we already figured that out. Listen, stop deleting comments, please. Stop deleting comments. Just leave them. They're fine. Ignore them. If Kevin feels like I'm tearing Diddy down, Kevin is clearly new here. I don't know what the hell he's talking about. I'm not paying him no mind, okay? Diddy's not innocent, but he ain't guilty of everything either. Let's be clear. Period. Anyway, back to what I was saying. I ain't got time for them. These case laws that they're citing do not actually line up with this case. And technically, CJ, I'm not even giving my opinion. I broke down. If they go back over my videos, I have broken down this case and I've been on point. Everybody else ain't been on fucking point when it comes down to breaking down the government. And that's a fact. And I don't give a damn where y'all going or who y'all listened to. When I broke down them 35 predicate offenses, I was telling people, go look up the 35 predicate offenses. Come back and tell me one of the offenses and how it applies to this case. And guess what? People started doing that and people started gaining knowledge. Period. I'm not over here puffing y'all up and bigging y'all up with misinformation. When I tell y'all what happened in court, when I go grab them transcripts and I start reading them transcripts, I'm very close to what the transcript said. I may not be verbatim because I'm writing things down in court, but I'm very close to what the hell was said in court. I'm reading a document, Dodo. Anyway, these case laws, especially this Taylor one, I don't see how they threw me with the whole crack cocaine thing. That does not align with this case right here. You're welcome, Michael. This doesn't align. The crack cocaine, they did a lot of drugs, but they didn't do no crack cocaine. They might have did a little booger sugar, but they wasn't done a little tootsie, you know? It might have looked like Skittles in their nostril, you know what I mean? But they might have popped the pills, took a line, but they didn't do this. So that's throwing me right now. And if it's throwing me, it'll probably throw the jury too. Anyway, back to what we was talking about. Where was we? I lost my point. Okay. We're in the furthermore. All right. Further, at least 2 other circuits have applied Taylor in holding that narcotics activity satisfies the interstate commerce requirement under the RICO statute. So then they cite United States versus Millen and Machulia. I don't know how to pronounce last name, this name right here. I don't know how to say that, but whatever. And they say it also charges other elements required for both RICO and VICR offenses, a nexus between the enterprise and interstate commerce. The market for illegal drugs constitutes commerce over which the United States had jurisdiction. All right. The government provided evidence that YMM engaged in daily drug trafficking over a period of several days. Drug trafficking is a type of economic activity that has been recognized to substantially affect interstate commerce in the aggregate. Now, again, when they start putting case law to try this right here, this whole thing right here is not going to help them. This is not helping them when it comes down to drug trafficking. Not helping them. That Henny Glasses in the chat. If this right here confused the hell out of you when it comes down to Diddy case, because Diddy wasn't moved. Did it? Is it okay? Okay. I see a couple Henny Glasses. The y'all sitting there like, what does that have to do with Diddy? So this did not help the government at all. Okay, for that reason, courts in this district have also consistently instructed the jury that narcotics activity satisfies the interstate commerce element of RICO. And once again, they cite United States versus Julio. Okay, Julio Martinez Alejandro and Louis Belladat. A lot of y'all, that right there. Okay. I don't know, murder. I don't know. So they cited that case and said, in addition, Congress has determined that all narcotics activity, even purely local narcotics activity, has an effect on interstate commerce. Thus, if you find that in the course of the racketeering activities, members of the enterprise trafficked in narcotics, this element is satisfied. Now, they should have just stuck to that. Y'all see the broom in the background? They should have just stuck to that, to this case right here. Because with that sentence right there, that makes sense. Because guess what? The assistants, a lot of the time, the assistants actually were the ones that were moving stuff. And Jane testified to the fact that she went to the Mapleton home, or one of them LA homes, and she picked up a package from the security booth. And that was coordinated between her and KK for her to pick the package up. And KK said she was going to leave the package with security. And then Jane went and picked up the package and got on the plane with it and got down there to Miami, and she gave it to Diddy. And when Diddy opened it up, it was e-pills. So Jane trafficked e-pills, but KK coordinated that. So those little activities right there is where the government is building the enterprise because of that. I don't know. He's not in general population. From what I understand, he's in a whole separate side of the MDC, but I don't know. I honestly don't know where he is. All right. Then they cited United States versus Torres. Okay. And in that case, interstate commerce includes the movement of goods, services, money, and individuals between states. Congress has determined that all narcotics activity, even purely local narcotics activity, has a substantial effect on interstate commerce. Thus, if you find that in the course of the racketeering activities, members of the enterprise trafficked in narcotics, you may find this element satisfied if it is not necessary for you to find a particular defendant knew the enterprise was engaging in interstate commerce. Now, they need to take this whole part right here and 86 it. This has nothing to do with it. This right here, for me, explained what they're doing. For me, I don't know if it explained it for you, but it explained what the government is trying to prove to me. All this other extra stuff, they cited a bunch of other cases that align with that last part that they said. Now, if they stick to that little part, that's fine. But when they start getting into these other cases where it's sounding like there were big quantities that were trafficked, I'm like, oh, hell no, that don't apply here. Okay. Now they're talking about venue. All right. The government respectfully requests that the court modify the instructions currently and included in this discussion a venue that ministerial functions and preparatory acts according in the district. Shut up, I'm not getting my glasses, leave me alone. Are insufficient to establish venue. The circuit has held that venue may be satisfied for SCX trafficking where a defendant contacts a victim who is located in the district for purposes of enticing them to engage in SCX trafficking. So basically, what they're saying is just because people were in the same state, because remember, in Cassie's, the Punisher said that he was in New York and they would just ring a ding ding him when they were in New York, and then he would go to where they were within the city, and that wasn't considered trafficking. But they're talking about the venue, okay? Then they cite United States versus Walsh, and it says finding venue satisfied where a minor testified that Benjamin first contacted her using Facebook Messenger in the fall of 2015 when she was living in a residential treatment center located in the District of New York. Hold on one second. Did they just say a minor? Did they just cite a case where there is a child? Located in Southern District of New York. For purposes, wait a minute. For purposes of enticing the minor to engage in in prostitution. I'm sorry, I said preparatory. I jumped the sentence down. Since the conduct in Walsh was erroneously to be construed by the jury as merely preparatory, the government requested that the court modify this portion of the venue instruction to reflect the language in United States versus Beech Nut Nutrition. Okay, by clarifying that act that the preparatory that are preparatory to the offense and not part of the offense are insufficient to establish venue, whether the crime is being continued or non-continuing. Venue is not proper in a district in which the only act performed by the defendants were preparatory to the offense and not a part of the offense. Emphasis added. Okay. However, the inclusion of the term ministerial functions may further confuse the jury, and in any event does not appear to be relevant to the conduct in this case, nor is the government aware of circuit precedent for that portion of the instruction. Accordingly, the government requests that the reference in ministerial functions be omitted. So they want that little part right there taken out. Okay. Now let's get to this part. All right, let's get to the count 2 and 4 proposed instructions. All right. The government has argued that the defendant committed SEX trafficking with respect to Cassandra Ventura for count 2 or Jane for count 4 over a years-long period. To find the defendant guilty of these counts, you must be unanimous that the government provided beyond a reasonable doubt all the elements of the charge with respect to at least one specific instance of SEX trafficking within that period. As to that specific instance of SEX trafficking, you must agree that all the elements were met beyond a reasonable doubt, but you need not agree as to the way in which the elements are satisfied or all the details of the instance. So basically, when it comes down to the trafficking of Cassie and Jane, they just need to all unanimously agree that there was trafficking that happened, but they don't necessarily have to pin it down to one specific instance. Okay. For counts 3 and 4, that would be, I don't know if that's going to be the trafficking. The transportation. The government has argued that the defendant violated federal laws regarding transportation. Yes. So we're talking about the transportation to engage in prostitution. With the respects to Cassandra Ventura, among others, for count 3, and with respect to Jane, among others, for count 5, over a years-long period. To find the defendant guilty on these counts, you must be unanimous that the government provided beyond a reasonable doubt all the elements of the charges with respect to at least one specific instance of transportation to engage in prostitution within the period. As to that specific instance of transportation to engage in restitution, you must agree that all elements were met beyond a reasonable doubt, but you do not need to agree as to the way in which the elements were satisfied or all details of the instance. So that means that if they come to when they get down to the SEX trafficking of Jane and Cassie, they don't have to say, yes, this is the specific one right here because this, and this happened. They don't all have to agree on that. What they all have to agree on is that there was some form of transportation or trafficking that happened. That's what they're saying. That's what they're saying. So they don't have to say, oh, yeah, the incident at the International Hotel, that's the incident right there. That's it. That's how we got him. Somebody could say it. Okay, so if I say, well, he took Cassie from LA to Miami and they had this freak off. And somebody else says, well, no, he took her from New York to LA. Or with Jane, he took her all the way to Turks and Caicos and they had a freak off over there. If other people are, if you're able to pinpoint that there is a moment where you see that there was an instance where the government proved that, then it's a unanimous decision that it happened. But they don't have to come before the judge and say, this incident right here is where, what, they don't have to do that. They just everybody has to see it in an instance and agree that there was the action that actually happened. All right, so that is the government side of things. Now, if you were waiting for the defense, I got you. I got you. Y'all get the likes up. All right. So here we go. Now, the defense sent theirs before the government, but because the government had such an uproar this morning with people talking about charges being dropped and all of that, I wanted to read the government first. But this is what they proposed first. All right. It says, dear Judge Submarinian, we submit this letter in further support of our requested edits to the court's proposed jury charge and to elaborate on some issues referenced in comment bubbles in our requested edits and objections to the government's red line edits. All right. So this is the defense, y'all. A, California penal law. Oh, they're going under section 137A, racketeering, Act 3. But that's not, okay, let's read. The defense requests a modification to the proposed charge regarding Racketeering Act 3, bribery in violation of California penal law. Okay, that's what it is. That's the bribery that they're going after right now. Now, it says the requested modification clarifies that a bribe within the meanings of the statute means something offered with the culprit intent to unlawfully influence the content of the testimony. Oh, you know what? I don't have this. Wait a minute. Hold on, you guys. I was moving so fast this morning. Let me get this for y'all. Hold on. Y'all gonna have to deal with the time and all of that being at the top. Oh, hold on. The government has, the defense has 12 pages, you guys. I'm not gonna be able to read all of this. I mean, this is a lot. Y'all gonna lose interest. I already know. Y'all have a short attention span. Okay? I know who I'm dealing with. You're right. Only God knows the truth. We don't know. We don't know. But anyway, no, I actually have CPTSD, which is complex post-traumatic stress disorder, which is also known as continual post-traumatic stress disorder. Okay. All right. So they are bringing up the bribe, okay, which within the meaning of the statute means something offered with the culprit intent to unlawfully influence the content of the testimony or information of a person with whom the bribe is given, where the person will be giving testimony or a report to law enforcement. It further clarifies that an attempt to prevent a person from appearing or reporting altogether is not sufficient. So basically, what they're saying, I don't know, it might be Jonathan. So basically, what they're saying, all this means go grab a snack and a drink. Yeah, because people will be like, oh, she's fine. She's so fine. She don't. Honestly, I don't feel like, while I'm going into another room, to be honest with y'all, I really don't feel like the defense needs much explaining, because we all understand the defense. We all understand what the defense is saying. We all understand what the defense is trying to get across. We understand the defense has one job. The defense has one job, and their job is to create reasonable doubt. That's what their job is. They don't have the burden of proof. The government does. Anthony said, I agree. Everything the prosecutors have presented may be true, but they have not proven it without a doubt. See, now there's an opinion, and sad to say that man walking. I don't know if he's going to walk. He may walk. Here's the thing. You know what? Let me do this. We're going to read the defense, okay? I'm going to read the defense. Let me change my background. Hold on, you guys. All right. I've changed my background. Mac Daddy, you need to relax, okay? Well, okay. So one person says they haven't proven it beyond a reasonable doubt. And CJ says the rug trafficking has to stick. Oh, Marianne, you're going to have to go back, baby, because we've been on here for 80 minutes already. We've been on here for 80 minutes. And I have gone through the government's whole thing. I've explained what they are doing, what charges are actually being dropped, which is attempted kidnapping, attempted arson, and aiding and abetting to sex trafficking. But they have not dropped the sex trafficking charges. They only dropped the aiding and abetting portion. Henny, I just got in. I stopped following this case, but I've been listening now and then, and he's walking. Okay. I'm always agree with Anthony. I'm not sure, but your temp is up this AM. What you mean? You think we getting ready to, we got another hot day? I told Mook about this yesterday. Wait, what you mean? Just got in listening. Hey, Rochelle. All right, so all right, we have our poll. And so the question was, will the government use any of Dr. Hughes's testimony in closing? 22% of you said no, 35% said yes, 44% said maybe. So this is what y'all have put on down here in response to the poll. My bad. That's it right there. All right. So, all right, I've gotten that poll. The poll has ended. Let's do a question. All right. Y'all got y'all first question of the day. Will Diddy walk or not? Tell us why. Answer the question. I'll be looking in the comments. They're going to keep him from buying baby oil, and that's about it. You know what, Anthony? I'm done with you. You going to the water table. Yeah, he def ain't getting life, but he going to get something, whether it's community service with rehab or an AA program. This is what I'm saying. I don't think he's walking. He going to get something. Even if he just gets hit with the trafficking, or let's say he gets hit with the trafficking and the transportation to engage, he's getting something. I don't know, like the RICO stuff, I explained to y'all what they was going for, and I was actually on point. Okay, remember Diddy alleged having dirt on people? Yes, he's a freak bug. He's not going to walk, but not as much time as first assumed. I agree with that. I agree with that right there. Who said that? Sean, I agree with you. People wanted Diddy to be jailed so bad. Some people may. I don't. Let me explain something to y'all. I have a black son that's incarcerated. I'm not an advocate for prison. Unless somebody is completely heinous and there's no hope. People who touch children, they need to honestly get the unaliving penalty. Serial unalivers, put them in Click City. I think complete banes of existence deserve to be in jail. Banes of existence. But I don't advocate for jail. And let me just say this. I'm very much, and I'm going to be honest with y'all, I'm very much offended when people say that I'm advocating for Diddy to go to jail. I'm not advocating for that. Have some of the things that he's done that's been talked about in this case been egregious? Yes. Are those freak offs? Yes. Are they? Yes. Are they? Yes. But I also know that Diddy was heavily under the influence of drugs. I didn't say it was okay for Diddy to cheat, but if she didn't want to be there, why cheat? Just leave. Well, first off, Diddy let it be known what it was. So is it cheating? I want him to go to rehab. I want him to go into intensive therapy. I want him to get help. Get help. Get help. R. Kelly, listen, R. Kelly needs help too. I ain't, listen, I don't think life in jail is going to help the situation. I don't think life in jail is going to help the situation. I have watched people go into prison and come out worse than when they went in. people don't get rehabilitated and become upstanding citizens. I don't. I think you give them, look, either you gonna go in here, you gonna go into this intensive therapy and rehab program, and you're gonna be sentenced to that for X amount of time. 5 years in an intensive therapy program and rehab versus 5 years in prison. Which one do you think would be more productive? 10 years of intensive therapy or you go to jail? Which one are you taking? If you're going to lock a person away where it's going to teach them to be a better person, teach them to heal their traumas, rid them of the things that make them corrupted as a person. And I know that sounds crazy. Exactly. Jail is business. I think what Diddy did is deplorable and disgusting. I think him putting his hands on Cassie the way that he did over the course of years is disgusting. And it's egregious. I don't say probation and rehab. No. You are confined to this place. I think he's walking. It was a lot of sex going on, and that's not illegal. Prostitution is illegal. I'm not going through this with people again. Did he break the law? Yes, he broke the law in some instances. How did he break the law, Henny? Because he paid people for sex. That's prostitution. He beat on Cassie. He beat on Cassie. He had his assistants purchasing drugs. He was taking illegal substances. Purchasing drugs is illegal. He broke the law. He did. He did break the law. Hey, Darlene. I didn't say nothing about a child molester. I said they need the death penalty. I agree with you, B, what you said, but people who touch kids, you need to be unalived. Now, if it comes out that there was some egregious acts with these children, that these allegations with the children are actually true, I stand on what I said. Because anyone who hurts a child deserves to be unalived. No, not even castration. Remove them from the face of this earth because they are a cancer that corrupts people and changes the very fabric of who people were destined to be. I stand on that. Now, I have to read some of this the defense, because people will be like, oh, she only read the government, she didn't read the defense. Okay, so they're going for the bribery, and basically what they're saying is it wasn't bribery. It's what they said in court yesterday. They were saying that it wasn't bribery because there was no case that was going on. Okay? Yeah, he did. He changed people. He altered people. I'm back. I'm sorry. A lot was happening here. You're good. So they're saying that because of that, it's not bribery. But the bribery comes into play because nobody knew. They withheld evidence. I think it's more obstruction of justice than it would be bribery. One thing I learned about this case for sure, I'm not flying nobody. Anthony, you learned. And see, that's the good thing. When you know better, you do better, because this is what I've been trying to tell people. All that flued out stuff that y'all doing, yeah, y'all might want to hold off on fluing anybody out, okay? Nobody should be getting flued out nowhere, no more. Not to engage in commercial X where now I done paid for your ticket for you to come here and we have SEX. I need you to say in writing that if anything actually goes down between us, that you with it. That if we were to engage in intimate relations, that you with it. I pay for your ticket, but let me just say this. If it happens to go down, you with it. And I need a video holding a newspaper that says the date. And you say I'm not being actually trafficked or held against my will. You better get consent forms for everything now. Hold on one second. God damn it. I've got so many chargers that things get all twisted up. And I hope I did. All right. My sound might start to mess up, you guys, because I have to unplug the microphone. I have to unplug the mic. My battery's dying. This phone right here, I gotta get a whole new phone because this phone does not hold a charge no more. I've been on here with y'all for 95 minutes. And the battery is like, yeah, okay, that's it for the day. Hold on, y'all. Make sure y'all don't see me. Let y'all don't see this. Jesus Christ. It's freezing cold in here, but watch how hot it gets. Okay, can y'all hear me or is my sound jacked up? Hey, Darwin. What's poppin'? Yeah. Anthony said, some will say he changed people and some will say people change themselves. Money is the root of all evil. A lot of people sell themselves for their own gain. It goes both ways. Well, here's the thing, Anthony. It's not money that's the root to all evil. It's the love of money that's the root to all evil. And at the end of the day, Diddy loved money. You're good. Just a little background noise. It's white noise. Oh, Lord. All right. So now the defense is also saying SEX trafficking instructions generally. And it says the defense tremendously objects to the government's proposed additions for SEX trafficking instructions. The court's proposed charge regards counts 2 and 4. Track the language of the statute and available pattern of instructions. The court's current proposed charge would purportedly and adequately inform the jury of the law. They're quoting them, right? The government seeks to undo the court's efforts by proposing voluminous, one-sided argumentative additions to the charge that are fundamentally unbalanced and only point towards how guilt is proven. The government's proposed additions are improper, legally unsupported, and will constitute error if charged to the jury. The court should reject the government's request to inject inaccuracy and imbalance into the charge, and to argumentatively inject the government's theory of the case into the charge. So basically what they're saying is, look, this is the defense now. This is the defense's side. We talking the defense's side now. For those that she only talking about the government. The defense's side is saying, we don't like the way that they breaking down this case. The government, they being one-sided with it. That's only speaking to people who have been found guilty. We don't want it in there. Now, at the end of the day, I would say that the government is supposed to cite case law that backs up their case. Shout out to everybody who was new to the channel. Thank you for getting me to 15.3. This has been an amazing, amazing journey with you guys. Um, and I am totally grateful for everybody who comes in here. Whether you like my content on this specific topic or not, I appreciate you even coming in here. I hope that anyone who came in here, that it actually just caused you to stop and think, maybe learn a little bit of something, or not, you know, or at least, at the very least, that you're entertained. I appreciate everybody's perspectives, even if we don't agree on them. I love the way that everyone that I have had dialogue with, that we have gone back and forth, that it has been an intellectual debate and not an argument. It's been a debate. Even the people who pluck my damn nerves with their comments, I appreciate y'all too, because you didn't have to come in here, but you did. So salute to everybody. Welcome to all of the new people who are here on the channel. I appreciate each and every one of y'all, and I don't take y'all for granted, okay? I don't. Just stick with it, because, you know, you may not like me on this case, but you may love me on another one. I'm just saying. Anyway, so the defense is saying, look, we don't like the way the government is putting that out there. And they also cited their own case, which is United States versus Copestein. All right. And in that, it says sufficiently imbalanced. Okay. That's all that they quoted from that. And then United States versus Dove, they didn't really give us too much on those case laws. I don't know why they didn't. But anyway, they also said the government cited no procedural authority, stating that its proposed one-sided additions to the ex-trafficking instructions are legally appropriate or required. Indeed, it cites no authority at all, stating as much. The government cited Second Circuit case law does not support any of its proposed additions to the charge. In fact, United States versus Rivera found error in the district court's instructions directing the jury to focus on the particular Jane Doe. Okay? So now they're saying in that case that that is not what happened. More broadly, nothing in these decisions directs courts to marshal the government's evidence or theory of guilt in the charges, or identify and exclude what particular vulnerabilities or means and methods might be issued, or even endorse such instructions. Okay? So they go into that case. They're also going into they don't like the instructions on Racketeering Act 6. Okay, and they say that the court should not charge the jury under U.S. Code 18, subsection 1591D, because it's unconstitutional as written, and because including a charge on its provision would be a constructive amendment of the indictment in violation of the Fifth Amendment grand jury clause. So they're citing that they're violating constitutional amendments when they're putting out their instructions for the jury. So they are going against them on that instruction. Let's see what else they're going against. Voluntary intoxication. Now, this is a different one, all right? The voluntary intoxication defense applies to more than just specific intent crimes. Intoxication is a defense to a crime so long as it negatives a required element of the crime. So the government is saying intoxication is a defense to a crime. Nino. I have a question. Yes, the defense. This is the defense. What did I say? What did I say, Melody? What did I say? Yeah, I had to tap the screen for a second because I already read the government. I'm reading the defense. Did I say the government? Because when I started reading this, I said the defense. I might have. I don't know. You said the government, girl. Okay, well, then I correct myself, but everybody already knows I'm at the government. I mean, the defense, because I just finished reading the government. But now the defense is talking about voluntary intoxication, and they're saying that intoxication is a defense to a crime. Let me say this. Let me ask you this. I don't know if anybody got pulled over for a DUI. I've never gotten pulled over for a DUI, right? Is that a defense to the case? Have you ever known personally, and I'm being so serious, have you ever known anyone to get off of a crime because they were intoxicated? Okay, I don't know anybody. I don't know anybody who got away with that. I'm talking about everyday people. I ain't talking about celebrity. Charmed Life said, "What is no?" Proper. Proper. I love it. I love it. I am confusion. Wait, because I'm confusion. Let's read more of what they're saying, because that on the surface of itself, I am confusion. So I'm not being, I'm funny, but I'm not being funny at the same time, because safe what? All right. So they cited some cases, all right? They cited United States versus Dupree. Any crime that requires intent, knowledge, or willfulness accordingly may be negatived by intoxication, which negatives the required mens rea. So they're basically saying that because the person is intoxicated, um, it negatively affects the mens rea. Mens rea speaks to intent, speaks to state of mind. It's the intention or knowledge of wrongdoing that constitutes part of a crime, as opposed to the action or conduct of the accused. That's what mens rea is: state of mind and intent. So, Your Honor, I was so drunk that I had no knowledge of what I was doing. That has not worked. I mean, you probably can use it as a defense, and that's what they're saying, but I don't know. Yeah, yeah. Mens rea. Intent and knowledge. Okay. So y'all remember that. Remember that. You get into any, yeah, it is. If I can't help that. I'm gonna use that next time. Although the Second Circuit has indicated that Albert, in the narrow context of the federal bank robbery statute of voluntary, okay, so they were citing um, they've cited a lot of cases, okay, to back them up. The forced labor, I can tell you right now, okay, this is basically from what I'm seeing, what they stood up in court and said yesterday. Um, They don't feel that there was enterprise established. They don't feel like there's a drug predicate that should be used. They don't feel like he immunized the witnesses. They basically, the government, when they stood up yesterday and they gave their Rule 29, it's basically the same thing that they're saying in this letter. And all they're saying is, we don't feel like the government proved their case beyond a reasonable doubt. And we have doubts about a lot of the stuff that they were saying. Okay. Um, None of the witnesses were credible. Like, this has been the defense's defense. But again, that is the defense's job. So, yeah, when it comes down to their instructions, they're shooting down everything that the government does. But they're, in my opinion, that's what they're supposed to be doing. I don't see anything that is standing out to me right now as that I didn't hear in court. I heard all of this yesterday in court, and I told y'all what the government came back, what the defense came back and said. So at the end of the day, I just feel like this. From everyone who has spoken about their interactions or their time with Diddy, he's a horrible employee. Horrible. You couldn't pray and get worse if you tried. As far as some of the conditions that they had to work underneath, okay? But with money comes power. With power comes corruption. And I believe that some of this power may have tainted his judgment, his perspective, may have created a bit of a complex within him, has given him authority that obviously caused him to not make the best decisions in life. In this case, I will say Diddy is guilty of a lot of things, but he ain't guilty of all things. I think each person that has spoken, I think Diddy affected them in a negative way, whether it was the intent or not. I sound like a regular Robert Shapiro. You should have defended OJ. I don't know if that's a compliment. Is that one of those backhanded compliments, or is that an actual compliment? Anthony too, because we already have an Anthony in here, and I don't know if that's not the same Anthony. So you're Anthony too, right now, because we have an Anthony. It was in Massachusetts. Okay. Ivan Curry was horrible. I still have a video somewhere of the girl running through the streets naked shouting, "I set her free." Wow. It seems as if you're holding back. You can't be everything to everybody in your analysis. I'm not holding back. The thing is, what you're seeing, Jonathan, is my true thoughts. This case is not as cut and dry as people do. And first of all, let me explain something. I'm a Sagittarius, so I have to analyze everything. I agree with that, loving myself. Being a freak is not, but they didn't even charge the obscene matters. You see what I'm saying? And with all the freak off stuff that was going on, I just knew that the government was going to go for the dealing in obscene matters Like, they would have gotten that. I'm surprised. Like, the government, honestly, they dropped the ball with some of these predicates, okay? Y'all holding on to this kidnapping. Y'all holding on to this arson. Those are shaky at best because there's no tangible evidence to back that up. See, that's the thing. When the jury goes back there to deliberate, we have had, what, about 35. It has been about 35. I lost count at 33. Because Brendan Paul was 33, and then there was 2 experts after, so that's 35 witnesses. The transcripts are about $1,500 to get them in their entirety. I don't have a few of them, but they dropped the attempted arson. They dropped attempted kidnapping. I don't know if the whole charge itself has been dropped. Just like they dropped aiding and abetting in the SCX trafficking, but they're still charging X trafficking. So we have to see what the final instructions are going to be, but they've taken those portions out of. You think it was proven by Capricorn Clark? I mean, I'm not saying it didn't happen. Understand, when I'm saying it's not proven, I'm not saying it didn't happen. I wasn't there, so I can't say it did or didn't happen. Only Capricorn Clark and Diddy know. And the people that were involved, like D-Rock and whoever administered the lie detector test and all of that, only those people know what really happened. But based off of what we got, when the jury goes back, hear me out before y'all start coming for me. That's the only thing that I ask. Hear me out before you come for me. We've had 35 people come and testify, right? The jury is not going to want to take the time to go through each and every testimony. I don't see them doing that. But now that they've narrowed down Capricorn Clark, all you have is her word. And all you have is the prosecution's side of it and the defense's side of it. There's nothing in between except for that one line from the LA detective Ignacio, where he said he saw a bad boy vehicle in the back at Kid Cudi's house twice. Once going up the hill, one coming down the hill. And that the tints were too dark on the car for him to be able to see who was in the car. So there's no tangible evidence to actually look at that says that this thing happened. You just have her word for it. And it's either you take her word or you don't. He doesn't. He places a bad boy vehicle there, but he does not say, I saw Capricorn Clark. I saw P. Diddy. He doesn't say because he didn't see. He just places a vehicle there. So we don't know if that's going to be enough for the jury. I'm not on the jury. I'm not on the jury. If I was on the jury, I would have remembered that detail and I would be fighting for that. He did get a call from Capricorn Clark, but where's the phone record? They pulled everything else. Y'all didn't pull a phone record that corroborates that there was a phone call made. Y'all, maybe they couldn't subpoena because it was so far back, they couldn't subpoena GPS. Maybe they couldn't get all of that stuff. But I'm sure that if she remembered her number from back then, or even the carrier or whatever, or even if he did, they would have been able, I don't know, they don't have. There's no proof. Even with that, Melody, there's no proof that the call happened. You have him saying it and her saying it. And Cassie. I believe Cassie testified to the fact that there was a phone call that was made. So you have those things. But do you really think that... Do you really think that the jury is going to say, okay, well, with this, let's go back into the transcripts? If they do, then I can see the California one. But I wasn't even talking about California. I was talking about New York. So you skipped ahead a bit because I didn't even get there. So let me finish my thought with the New York case. There's nothing that corroborates any of the story of what happened in New York. Nobody else can testify to it. Okay, I'm going to turn off. Let me get my thoughts out. You just have her saying that this incident happened. Nothing else. D-Rock is not coming to testify. They don't know who the guy was that administered the lie detector test. I don't see the New York one sticking. With California, like I just said, you have the LAPD officer. Yes, now you have Kid Cudi, you have Cassie, you have Capricorn that are all saying that the phone call happened. But is that going to be enough? Is the jury going to say, bring us Capricorn Clark's transcript, bring us Kid Cudi's, bring us Cassie's? They might bring us Ignacio's. Are they going to say that? Are they even going to remember those details? They've heard a lot of testimony. Are they going to remember those details? If they remember those details, then the California one might be able to stick. But I've already said that the California one was kind of shaky. But out of the two, I think that's the one that has the most for people to actually look at. But is it beyond a reasonable doubt for the jury is what we're talking about. That's what we're talking about. Beyond a reasonable doubt for the jury. With the arson, you have Cassie, Cudi, Capricorn. I think they might have questioned Mia about Kid Cudi, but I don't know if they talked about the bomb. And look, I can't even remember everything, and I was in court for that. Is it strong enough? To me, those are weak at worst. They're weak at worst. It's nothing tangible. And even with that, what makes the arson suspect, though, is the fact that there has been testimony from Mia that she's gotten out of speeding tickets because of who she worked for and who was in the car, which was Diddy. She did testify to that. So when arson investigator Jimenez took the stand, and Jimenez says that oh, look, people left. They didn't like what I had to say. Oh, sorry. The fact that the fingerprint cards disappeared, and it was disappeared by an LAPD officer, even though they didn't want that thought to be out there, it's there. Because we already heard that testimony from Mia. But is it going to be enough for the jury for reasonable doubt? Is it? I don't know. Because we don't have anything that ties Diddy. But the moment was when they said that the DNA from the fingerprints came back to a female. Now, I said, would it be far-fetched to say maybe KK did it? Maybe he made Capricorn Clark do it? I don't know. We will never know who was connected and tied to that arson because the print cards disappeared. And here's the thing. That case is not closed. It's inactive, which means that that case is still open. Well, not open. Well, yeah, it's open, but it's inactive, meaning nobody's working the case. So evidence went missing on an active case. That's suspect in itself. But again, those may be considered things that bring doubt into the jury's mind. Okay? The things that I think are proven beyond a reasonable doubt are definitely the trafficking and the transportation to engage. I think those two are beyond a reasonable doubt because there's been an immeasurable amount of evidence to back that up, right? The forced labor. I don't know what it's like to be a personal assistant. I've never been a personal assistant to a celebrity, ever. Ever. But I've worked a job. I've been a business manager where it was just me and my boss, and I did what my boss told me to do. some of those things did not include business things. So at times I said to him, I feel like a personal assistant, because as the business manager, I would watch his kid. When his kid would come to the office, I would watch his kid. I would help his kid with his homework. I would pay his wife's bills, pay his mistress's bills. Okay? I would make sure that certain personal things of his that had nothing to do with the business got done, but I was not 24 hours on the job. When I clocked out and went home, unless I was doing dispatch for the office that night, I was not working 24 hours. There were times when I had the phone. The phone was brought home with me to dispatch to the drivers overnight. So when that phone rang, I had to wake up and I had to answer the phone. I couldn't miss the call. 20 hours to 22 hours a day, that's a lot. And then even when you're off, you're on call, booking flights and things of that nature for his girlfriend, setting up hotel rooms and breaking hotel rooms down. I don't know. I would say for forced labor, creating an environment of fear was something that they did put out there for us. Because they all witnessed some form of violence or aftermath of violence, or like Mia said, she experienced violence where Diddy threw computers at her. Their job was constantly threatened. But if I'm being completely honest and transparent with y'all, George Kaplan, he resigned. He left. Daniel James, I don't know if he resigned or if he was fired. I'm going to have to go through that and see. But I think it was strenuous. I think there were things that were done that went beyond the scope of what they were supposed to be doing. I'm on the fence with the forced labor. And if I'm on the fence with something, me personally, I have to say it wasn't proven beyond a reasonable doubt for me. And y'all may not like that, but I'm being honest with y'all. Now is the time for transparency. And I've given y'all the prosecution's case. I've given y'all the prosecution's case. I don't know if that was proven. Let me show the chat and see what y'all are saying. We're talking about the forced labor. So let's do this, okay? Let's bring y'all into the conversation. Let's have the conversation. All right. Here's y'all next question. The question is, I'm going to put it down here right now. Did the government prove forced labor? Let me fix that because I don't think y'all can see it. I want y'all in my face. Oh, it's not showing the whole thing. I might have to do this as a poll, you guys. That's the question. Maybe I need to do a different question. And no, I don't want y'all all in my face. All right, if you don't understand what the question is, just ask in the comment what the question is. Can you pin it at the bottom? I can't because, you know what? Let me just do this. I think somehow you can pin the comment at the bottom. Well, that's not a comment. Let's do this. I'll do a poll instead. Okay, Sherm, I already know. Don't ask. Boom. Poll is at the bottom of the screen. Y'all let me know. Did the government prove forced labor? Vaughn said, you got me interested now. Now, they also, when the government was talking about forced labor, they were also talking about Jane and Cassie. And I'm going to turn the comments off. Whenever I need to get my thought out, I'm going to turn the comments off. I'm not being rude. I just want to keep up with, what my thought process is. They also included Cassie and Jane into the forced labor. And they're saying that with Cassie and Jane, they were forced into committing the labor of commercial sex. And what made it commercial sex was the fact that Cassie's home, everybody talks about Jane and this $10,000 rent every month. But Cassie also got a house in New York from Diddy. And Diddy was also paying her rent at her apartments, except for the one that she had in Studio City. So Diddy has a habit of taking care of the bills for the roof over people's heads. Right? Cassie had a whole music career that dangled in the balance when it came down to Diddy, that he was the one that held that in the palm of his hands. It was testified to by Cassie, by Mia, by Capricorn, by Deontay Nash. It was testified to that, yes, while Cassie had projects that she did separately, like the one that she did when she became friends with Brianna Bungalon and things of that nature, everything went through Diddy. And when Diddy got mad, Diddy taketh away. Jane, she told Diddy, I don't want to do these hotel nights anymore. She don't want to do it. Cassie didn't want to do the debauchery anymore, but yet found themselves still in the debauchery. Is that forced labor that they continue to do it for career, for roof over their heads, for livelihood? Is that forced labor, you guys? Yes, no, I don't know. Answer the question down in the poll. That's where we're at right now, where we're trying to see, is it actually that? I've given you the testimony. I've shown y'all how the government laid their case down. Now it's time to weigh everything out. I've even told y'all the defense, when the defense came, even though I was telling y'all smoke and mirrors, to give you reasonable doubt, because that's what the defense is supposed to do. I'm not bashing them. I'm not trashing them. The defense did a hell of a job. The prosecution did a hell of a job to me. I'm not bashing neither one, neither side. I did not like the way Brian handled Mia at all. I didn't like it. I did say that, and I'm standing on it. I didn't like the way Brian handled Mia. Didn't. Outside of that, that's that on that for me. But all of that aside, the difference between Jane and Cassie is, with Cassie, it was physical abuse that was involved. Jane, if I'm going to be honest with y'all, somebody remind me to get into Jane after this. So I have 43 people that have taken the poll. Y'all take the poll down there. Is that good enough for you? You trolling me, Diddy? Coercion, influence, and propositioning people into doing your will, desires for your personal gain, is forced labor. Okay, so Bark, I love what you just said there. I love what you just said there, Bark. DL Bark, I'm pinning your comment. I'm pinning your comment, Bark. I love that comment. Coercion, influence, and positioning people into doing your will, desires for your personal gain is forced labor. And you know what I love that you said in that sentence? You said personal gain. Personal gain. That is still considered a gain. And it does not have to be a monetary gain. Mia, yes, Diddy Witty, calling me Henny Penny. What's up, Diddy Witty? Still got to be found guilty of 2 charges. For the racketeering, yes. But right now we are going through different charges. So please join the conversation because I would love to hear what you have to say, James Gerald. I don't know, Mr. Elite, did you? He must be a lawyer, well worded. That was what I love that. Do the FO or get a beat down. Forced labor. Cassie was Diddy's employee. Paul, the trainer, was Diddy's employee and doing. Ooh, go, baby! I forgot all about Paul. You absolutely right. No, I'm not into FOs. Sorry, Diddy. He don't deserve life. I would agree with you, Vaughn. He does not deserve life. Diddy done took over the chat. You see that, right? It's too bad a lot of the people got pissed off when we started breaking down these charges. Told you, Mukavelli 16, she be having weird fans coming out. Look, and he came in here, and the snipers, I don't have very many snipers in here right now. The snipers was in here when it was jumping. It was still a game, but you just blew my mind because oh, the #1 hitter is up in here. Hi, Uniquely. Goal is in here. Uniquely is in here. I think CJ has tapped out. I think Goddess tapped out. I think Poppington tapped out. Dre. Oh, CJ's still here. Okay, good. CJ here, another top hitter. Okay, I got my big snipers in the building right now. You know what I'm saying? I got my other snipers. They on, they got other things they got to do. Let me tell you something. All my snipers, they're at work. Okay, they are at work right now. So they be in and out the chat. Don't snipe Diddy. Diddy's good. Dominican is in a building. Listen. Was y'all in here earlier? I do. It's a community. It's a community, Harold. I'm still here. Everyone in the chat is cool right now. We have fun. I'm at work. See? Yeah. Everybody's chill right now. It's when this number right here start going up and getting crazy that I need all hands on deck. Okay? For any of the charges, it only takes the one juror to come to reasonable doubt on each. That's a fact. That is a fact. That it only takes one. Actually, it takes one to make it a hung jury. You just got up and late. You good, Uniquely. They held it down today. You would be proud. Goddess was in here. Pew, 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 pew. She done stepped out the shadows. It does take one for a hung jury. But now, let's go back to what we was talking about. Gold Digger just brought up that Paul was also an employee. I forgot about that. She said, "I got my full attention." They was holding it down, okay? They was holding it down this morning, so much so I had to say, just let them go, like let them slide. I'm gonna turn the comments off. They're not gonna distract me. Y'all let it go. He was also an employee that was involved in the freak off. We don't know if Paul was Paul getting paid. Ooh, was Paul getting paid? I agree, Melody. And guess what? I'm gonna be there for them closing arguments. I'm not going in today for the jury charges. I'm not going in today. I will be actually probably live tweeting or doing the live tweets. I don't know if I'm gonna do that or not. I might wait till it builds. I don't know. But the government, the defense and the prosecution are going to be presenting their charges for the jury today. I'm not traveling from Jersey, you guys. I'm in Newark. And I'm not about to go take the PATH train to go to court to be there for 3 hours. It's not worth it for me. It's not worth it for me. If I was in New York still, if I was in Brooklyn, which I contemplated doing last night, going to Brooklyn and staying the night and getting up early in the morning to be there for court, but it's complicated. So I came back to Jersey. They dropped parts of the charges from what I'm gathering. Who was Paul again? No, Uncle Paulie was security. And then there was Paul the trainer. Paul was the trainer. And Paul was the one who, he was Diddy's trainer. And he got involved in the freak-offs between him, well, hotel nights, excuse me, between him, Diddy, and Jane. So Gold Digger brought that back to our recollection that Paul was actually, yeah, they dropped parts of the charges. They dropped the attempted kidnapping and attempted arson and the aiding and abetting in the SEX trafficking. But they didn't drop the whole charge of SEX trafficking. There was another trainer besides her husband. Yes, that's Paul. A Charmed Life. That was Paul. But Paul wasn't Jane's trainer. Diddy learned from that. Diddy said, Jane ain't getting a trainer up out of me. I'ma have the trainer. Okay, so is what's left enough for the RICO? I'm not sure. Like I said, they only need 2, okay? Bribery, oh my God, my eyes are starting to itch. I'm sorry, you guys. Bribery is one of the predicates they're going after. Kidnapping, forced labor, witness tampering, SEX trafficking, transportation to engage in paid intimate relations. That's the 6 that I could think of off the top of my head that they're going after. They did not go after, thank you, Diddy. They did not go after the dealing in obscene matters, which, like I said, I really thought that that was one of the predicates that they would have gone after, being that they had all this sexting that was going on between all of them. And all of these freak-offs and how they proved the transportation to me. Those last 2 charges, I would say yes to the transportation to engage in paid intimate relations is there. Abuse in this case is looked at as force and coercion. That's what the DV that everybody is talking about. I've been explaining this to people from day one, that this has been looked at as force, not as domestic violence, because it was used to force people to do things that they are saying they did not want to do. All right. So now looking at the poll that we did the government, oh, I said prob fired labor. Oh my God, at least y'all understood what I was saying. It was supposed to be, did the government prove forced labor? And 43% of you said yes, 35% said I don't know, and 23% said no. With that right there and looking at how close that is, you got 43% of the people saying yes. But then you have 57%. When you add up the no's and the I don't knows, you have 57% of the people saying no and I don't know. That's reasonable doubt, ladies and gentlemen. That's not proven without a doubt. There it is right there. This is what you guys have voted to. Even though I spelled things wrong, y'all still understood what I was saying. Um, what else? What else? What else? Did they prove forced labor? Okay, I'm gonna see if I can get this. Did they prove bribery? And how? Here you go. Here is your Q&A question that is on the screen. Did they prove bribery and how? So now let's go back into the story of he's probably guilty of them all, but even if 11 jurors agree, that one juror who doesn't on each charge separately kills the case. It's simple what defense has to do. Okay, so what you are saying is accurate. But what I'm going to say to you is if they come back, now you got to look at the Weinstein case because they had a hung jury on one charge. He was found guilty on another and not found guilty on one of the other charges. Each of these counts, they're going to, when they go to do this, they're going to say, okay, Madam Floor Person or whoever the floor foreman is, they're going to ask them to stand up and they're going to say to the charge of conspiracy of racketeering, what say you? And they're going to say, we, the jury, find the defendant. And then it's whatever. It's we find him guilty or we find him not guilty. Then they're going to say, okay, to the charge of trafficking in relation to Cassie. We, the jury, find the defendant guilty or not guilty. To transportation to engage in illegal sex. What say you? And that's how it's going to go. I don't think they're going to go to racketeering. What charges do you find him guilty? They may ask for specific charges. They may, because there's specific predicates that they're talking about. Hey, sexiest one. I just can't imagine that the jury will let him walk after all that proof. I don't think he's going to walk. I think he's going to get something, but I don't think it's going to be all of it. Okay, blackmail. Demanded $20K from Cassie's mom. Blackmail's not on here, though, Gold Digger. They did not go for blackmail. They went for bribery. They went for bribery. They didn't go for the blackmail. They didn't go for transportation to engage either. I mean, they didn't go for dealing in obscene matters. Yeah, Harold, I say the same thing. God have mercy, because this has got to be the most scariest part of all of this process. I think it's going to be time served. That's a possibility, Tony Miles. They could. I don't know. Could one of the hitters get Diddy a drink? He's limited. Diddy said he needs a drink, guys. Everybody throw a Henny glass in the chat for Diddy. There you go, Diddy. You got your drink. Yes, the hotel security was very believable. Okay, so Kim says yes, they proved bribery. Me too at Tony Miles. They might add an extra year. Pammy said, take that, take that. All right, so The hotel tape definitely solidified the bribery allegation. I like this. Bribery is the cousin of blackmail. This is true, but blackmail is a separate charge in the predicates, though. And I didn't hear them talk about Cassie's mom. They didn't talk about Cassie's mom in these charges at all. I'm wondering if they didn't apply the weaker charges so that the state can get him if he is acquitted. I don't trust the government with them drop charges. I don't know. And that's what I was trying to explain in the beginning of the video, that the kidnapping is charged at a state level in both California and New York. The bribery is also charged at the state level in according to California law. And bribery holds there's no statute of limitation on kidnapping. However, bribery holds a 3-year statute of limitation from the time it is discovered. So the bribery was actually discovered in 2004, which is last year, which means they have until 2027 to actually charge that. I think they did drop. I don't know if they dropped it completely. I'm just going off of the wording that's in that letter right there that says that the attempted kidnapping and attempted arson is gone. But what made me say I don't think they dropped the whole thing, I don't think so, is because they said they dropped the aiding and abetting in the SEX trafficking, but the SEX trafficking is still there. During the defense's attempt for the acquittal, they mentioned an issue with the kidnapping and arson not being legal charges in California and New York. Did that prompt the dropping of they did not drop the charges as a whole, as far as I know. However, they are legal. They are legal charges. There is no statute of limitation in the state of California or New York for kidnapping. And in New York, they have first degree and second degree kidnapping, and neither one of those degrees have a statute of limitation. If what two were up there? Tony Miles said if those two was up there, we would have gotten an earful. What two? What two are you talking about? He might just have a hard bid if he go to the wrong place. I just did 20 years in the feds. Gang, gang. Oh, goodness. Salute to you, Harold. 20 years. Sheesh. They need to charge him for hoarding, baby. Yo. Let me see. Do I have it in this phone? It's not in this phone. Y'all are lucky it's not in this phone because, baby, I have... Oh, yes, it is. Speaking of baby oil, look at this. This is a locked case. He had a locked case. Look how organized this is. It was neat. Baby oil in the locked case. What is that? A closet of baby oil. I have never in my life. A travel bag, baby oil, lingerie, and I don't know what that is, but this is... in his medicine cabinet. And this is a drawer of Astroglide with 2 bottles of baby oil in there, but a drawer full of Astroglide. It's not yours. It was Cassie's. Because Cassie said that she couldn't help herself. She had to buy baby oil. Listen. You are not alone. I am here with you. Hold on. What you want? You want aloe? What is this? The aloe and vitamin E? Or you want the coconut? Which one? Y'all see which one I like? Because this one is the one that's... when they out of this, I get this. But this is the extent of my baby oil collection, okay? This is the extent of my baby oil. I don't have racks on racks on racks. But Johnson Johnson. I don't have no Astroglide, cousin Pam, I promise. Oh, B, I got that too. I don't heat it up. The only heated up I do is this. I warm it up by rubbing it together and put it on my skin. It puts the oil on its skin or else it gets the holes, honey. I have a problem. I like women. Oh my God, Mr. Elite, that's too much. Yeah, that's a little too. That's damn near all CVS. Imagine his baby oil and Astroglide budget. Baby, I don't know. Put that down. And he has props. Look, look. No Astroglide. Okay, I'm telling you, he should be charged for lube and baby oil distribution and travel distribution, taking the state lines. Diddy, I have to say this. I've never seen a photo of Diddy being ashy. And his skin looked like it was smooth. Now we know why. We need to hear from Gina and Young Miami. I agree, Tony. Diddy, what's with all the baby oil and Astroglide? Diddy's menu. Diddy oil, Diddy glide, Diddy drinks, Diddy eye drops, Diddy pills, Diddy Tootsie, Diddy toys, etc. All for your FO pleasure. Yeah, you know what, Gold? Lord have mercy. Miss Parker, Miss Parker. His skin looks smooth, right? No. Diddy's skin looks smooth as heck. I'm not even gonna hold you. I'm not even gonna hold you. He was slipping and sliding and Astrogliding, in the words of Uda. Went from ashy to classy. That part. They're depriving him in there. Diddy, what's up with me? Oh, so I don't know. I think they have baby oil in commissary. Yo, his skin gotta be satiny soft. It has to be. He said, I'm so soft. Well, listen, you guys. I think that's going to do it for me. I'm about to go have me some breakfast because I ain't had no breakfast yet. Okay? I didn't have no breakfast yet. Hey, Tyron. I always thought that it was just the money when, like, showing the gold, the God and Kevin Hart. And Diddy started looking better. But now we know it's baby oil. Child, listen. I want to still support, but paused for a meeting. So when I rejoin, I'm going to be behind if y'all still cutting up in here. No, we about to cut it down. I'm about to go get me some breakfast. They only sell lotion and lip chap. Lip chap. He said, and lip in there. So lip stuff, that's it. No baby oil. They don't sell no baby oil in there. Diddy, was y'all swimming in baby oil too? Man, listen, all that baby oil. You want to know what picture took me out? This one. You want to know what other picture took me out? This one. That is a locked case. Look, y'all, there's a key and a lock. He was locking it up. And then this right here, the bag of baby oil and Astroglide. Was this going to the hotel? And then this. You already used some of them. How many bottles is that? Like 4 bottles is missing from there. But then, look, Diddy uses Zyrtec. He got regular medicines in there. He used Arm & Hammer deodorant. That looks like there's some Vicks in there. That's his damn medicine cabinet. And he used hemp's lotion. He got lotion in there, but he liked the baby oil. So he probably do like I do. He put the baby oil on, and then he put the lotion on. So if you want smooth skin like Diddy, you use baby oil and hemp's lotion. And if you want to smell like Diddy, at least in the armpit area, because we don't know what he was using as cologne, he used Arm & Hammer. I was trying not to talk about that because I don't know what that is. All right, everybody. That's going to do it for this edition of The Bar. The Bar is now about to go on a recess. I'm going to go eat. Mama, he puts the baby oil on the stuffs and the stuffs. Will didn't want none of this. He puts the lotion on his skin. That's what I said earlier, Barker. He puts the baby oil on its skin or else it gets the hose. Yo, I am so done. I don't know who's behind this Diddy page, but I'll be seeing you everywhere, and you are hilarious. Thank you for coming into the chat. Y'all, I'm about to end this live. I've been on here for 161 minutes with y'all. I love y'all. I will see y'all later. Where are you getting your food at in Newark? I live in Newark. I'm not getting any food. I'm about to go make me some food. But so far, I haven't really, like, ordered nothing from out here because my daughter is like, she don't eat from out here because she don't know what's good out here. So, I don't know. Any suggestions? Damn, I wonder what was in the Sean John cologne. The Sean John cologne smelled good, though. I will say that. That needs to be it. Anyway, I love y'all. Y'all have a wonderful day. High vibes to your day. Remember to vibe high so the bullshit don't stick. And I'll see y'all in the next pour up. Peace, everybody.